Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through Alabama House Bill 351, known as the Alabama Personal Data Protection Act, and its main requirements. The law, enacted in 2026, establishes consumer data privacy rights and regulates how businesses in Alabama collect and process personal information. Its main goal is to protect consumer autonomy and ensure transparency. Here are the key dates. The law was passed by the Alabama legislature on April 7, 2026, and officially signed into law on April 16, 2026. On May 1, 2027, the Alabama Personal Data Protection Act becomes legally effective. The APDPA applies to persons conducting business in Alabama or targeting residents. It covers entities processing personal data of more than 25,000 consumers, which excludes data processed solely for payment transactions, or entities deriving over 25% of gross revenue from data sales, regardless of the number of consumers whose data the business controls or processes. Exemptions apply to Gramm-Leach-Bliley Act financial institutions and Health Insurance Portability and Accountability Act covered entities, small businesses, and nonprofits not selling data, health, research, and patient safety data, Fair Credit Reporting Act, Family Educational Rights and Privacy Act, and Driver's Privacy Protection Act data, employment, human resources, and emergency contact data, and political action committees and parties. Businesses must focus on these key duties. Respond to consumer rights requests within 45 days. Limit collection of personal data to what is necessary. Maintain reasonable data security practices. Obtain consumer consent before processing sensitive data, and do not discriminate against consumers who opt out. Website owners must provide a conspicuous opt-out link on the website, post a reasonably accurate and clear privacy notice, detailed data categories, and third-party sharing online, provide an active email address for contact, and establish a secure online means for rights requests. Additionally, they must implement specific protections for minors, meaning parental consent for children under 13, and a mandatory opt-in for those aged 13 to 16 before selling their data. They must obtain consumer consent before processing sensitive data, and provide symmetric revocation, meaning if a user opted in with one click, they must be able to revoke that consent just as easily. Additional requirements include ensuring processors assist with consumer requests and security, establishing binding contracts between controllers and processors, ensuring de-identified data cannot be associated with an individual, and refraining from re-identifying de-identified data. Individuals have the right to confirm processing and access data, the right to correct inaccuracies in personal data, the right to delete personal data, the right to obtain a portable copy of data, the right to opt out of targeted advertising or data sales, and the right to opt out of profiling for significant decisions. The Alabama Attorney General enforces this law, providing a 45-day cure period to correct violations. Fines can reach up to $15,000 per uncorrected violation. Thank you for joining us. At Clym, we're here to help you navigate compliance with ease. Visit us at clym.io to learn more about our all-in-one digital compliance solution.